Ms. Chaitman, you said, look, just to get into the weeds on one little, not little point, but one point in some of the material you supplied us with, you said that the trustee, correct me if I'm wrong, the trustee and SIPC are running administrative expenses of approximately $100 million per year. But Mr. Harbeck says in his testimony that the trustees have only paid $1.2 million so far. Can you
I can
clarify that? Yeah.
Yes, the trustees' legal fees are...
Hit your little button.
I'm sorry. The trustees' legal fees have been approved for the first 15 weeks at the rate of $1 million a week. He then filed an application for another 23 weeks, and he's running again at $1 million a week. So if you project that for a year, it would be $50 million a year. And Mr. Harbeck has said publicly that the non-legal fees, the forensic accountants, et cetera, who are going back through generations to figure out the net investment, which of course is not required by the statute, Mr. Harbeck had said in the press that those expenses are running at the rate of $1 million a week.
Wow. So it's one of those cases, as is typical, and I see my time has come up already, cases where there's almost an incentive for, and I'm not saying that there is, I'm just saying on the face of it, there's an incentive for not things to move at an expedited basis because you have a pretty good fee there that's guaranteed to be paid for the period of time.
There's an inherent conflict of interest in the way the statutes.
That doesn't seem to be covered. Ms. Chaitman, do you have a thought on what the SEC's view and why that doesn't seem to make sense?
Well, the first I learned of the SEC's position was last evening when I saw their written testimony, and I have to tell this body that there is no authority in the statute for the SEC's position. In other words, you can read SIPA from beginning to end, from the first word to the last word, and nowhere does it say that the full protections of this statute are reserved for customers who make their own investment decisions, but not for customers who rely upon financial advisors. And if you analyze the economics of what the SEC is suggesting, instead of protecting investors, which is what we as taxpayers fund them to do, they are protecting the industry-funded insurance company because the vast majority of Americans don't make their own investment decisions. My clients are in their 70s, 80s, and 90s. They don't have the capacity to decide whether they should buy something one day and sell it the next day. They hire financial advisors and they go to brokers who make those decisions for them. They invest through Fidelity or Vanguard and they buy funds, and those fund managers make investment decisions for them.
Is it your view that if this interpretation were held up and this was the SEC's interpretation throughout, that it would seem to me that millions of investors who just give a more general parameter of investment authority to an investment house may not be covered by a failed account, a failed broker who then SFPC steps in on?
Precisely, they wouldn't be covered for the full 500,000. And the purpose of the statute was to instill confidence in the capital markets. If the FDIC tomorrow, in the next bank liquidation, decided, you know what, we don't insure the accounts except for the net investment, so we're eliminating all interest that may have accumulated over the last 30 years, and we're only going to pay the net deposit, there would be a run on the banking system. And the SEC's filing yesterday for this committee could create a run on the securities firms because no investor in this country has any idea what kind of coverage they have in the event that they're dealing with a dishonest broker.
First question. Are either of you aware of any instance in which SIPC has defined net equity the way the trustee is doing in this case? Ms. Coffey and then Ms. Chaitman.
Do you want to go first?
Yes, I'd be happy to. I can assure this committee that there has never been a case in a SIPA liquidation where SIPC or the SEC has taken the position that SIPC does not have to comply with the law. This is the first time in SIPC's history that SIPC has taken the position that net equity as defined by Congress does not apply to SIPC.
Professor Coffey and Ms. Chaitman.
Thank you. There are two things I'd like to say. First, we're not seeking a total bailout or restitution. All we're seeking is that the SEC and SIPC comply with the law. We're seeking the $500,000 in SIPC insurance that we were promised. But the statute clearly contemplates that a customer who deposits money with a broker for the purpose of purchasing securities is entitled to $500,000 in SIPC insurance based upon the customer's last statement. That's what the statute says. That's what the SEC has said in every case until now. That's what SIPC has said in every case until now. When a customer had a statement which showed the purchase of real securities, that customer was entitled to replacement securities up to $500,000, even if those securities had tripled in value. And how can we trust our government if Mr. Harbeck, the president of SIPC, can assure a court, as he did in the Southern District of New York in the New Times case, that even if the securities, which were never purchased because it was another Ponzi scheme, even if those securities tripled in value, SIPC would replace the securities up to $500,000. We had a right as law-abiding citizens to rely upon that statement and rely upon the law. Now, with respect to the taxes, there's no question that economically the Internal Revenue Service was the largest beneficiary of Madoff's Ponzi scheme because he was generating short-term capital gains and people were paying taxes on the income they thought they were receiving at the highest tax rate. But I think that the Internal Revenue Service and Congress have done a great deal to help investors on the tax side. There are proposals. Congressman Ackerman has a bill. Kendrick Meek proposed a bill. Senator Schumer announced the other day a proposed bill in the Senate, which will give Madoff investors a great deal of relief. It's not 100%. We're not asking for 100%. But on the SIPC issue, we're asking that SIPC be required to comply with the law.
Mr. Chairman, could I